Condon. I'm very pleased to be chairing this session on the topic of no contest settlements, which is really, certainly for us in Ontario, the other bookend of policy initiatives that is also reflected in the previous panel. If the whistleblowing initiative is an initiative about getting good information in to begin investigations, then no contest settlements is a relatively new initiative in Ontario that is intended to resolve matters even more efficiently and more effectively with respect to recovery for investors. So to address the topic of no contest settlements, we have a very distinguished panel here. I'm not going to give you the detail of all of their biographies, but you can read those for yourself in the materials. They each have a different perspective on the topic of no contest settlements. And we do have a sort of a flow or a logic that we're going to be using to address the topic. We're going to begin with Phillip Anisman, who has a long history of being both a participant and an observer in enforcement issues in Ontario, and he's going to begin with some of the history and some of the context for the introduction of the possibility of no contest settlements in Ontario. Then we're going to move to Kelly Gorman, the Deputy Director of Enforcement at the OSC, who is going to describe in broad outline how the program works in Ontario and our, albeit limited, experience with it to date. We'll move then to Stephen to get the U.S. perspective on no contest settlements, where this phenomenon has, of course, been in existence for a lot longer. And then finally, we'll move to Professor Anita Anand, who will give us a number of academic perspectives on the development of this procedure. So I'm going to, with that, turn it over to Phil and begin our discussion.
You know, I've been watching other speakers, and I don't want to appear ungrateful, but I have no intention of thanking either Fair or Osgoode for getting me here. And my guess is that by the time I'm through, you won't thank them either. Let me start quickly with the history of this. In the early 90s, 1990s, so with a few exceptions, since the early 90s, with a few exceptions in the early 90s, the OSC, at least, would not accept a settlement unless the respondent admitted the facts and admitted either that there was a contravention of the legislation or that the conduct engaged in was contrary to the public interest. The premise of the OSC's position, and it became quite rigid toward the late part of the 1990s and into the early part of this century, the premise was that the Commission's authority to make an order, a sanctioning order, was based on its conclusion that the order was in the public interest. And in order for the Commission to reach a conclusion on the public interest, there had to be a factual base for the conclusion, which required admission of facts and contraventions or a public interest admission. The difficulties with that position became apparent to OSC enforcement staff, certainly by the middle part of the last decade, 2005 and on, because what staff discovered increasingly was that it was difficult to obtain an admission in circumstances where the respondent was exposed to civil liability or wasn't prepared simply to make the admission because they thought that they had a fair case to defend. And what it resulted in a number of cases was lengthy hearings at a time when Commission hearings were increasing, and the OSC at least has always disliked protracted hearings and seems to be engaging in more and more of them. The OSC is a masochistic institution. But staff discovered that frequently they'd go through a hearing and the result would be, even if successful, a sanction that was no better than they could have got in a settlement much more efficiently without expending resources that could have been used on other cases. And as a result of that perception, staff began to consider alternatives. They looked at the SEC's practice, which has everyone here will know is a practice that has long followed a no contest approach to settlements. The SEC basically won't accept a denial of liability, but they also they require an admission, in effect, that there is no admission, but there's also no denial. So their settlements are called no admit, no deny. That came into effect in about 1972 in a serious way when they adopted their Rule 202.5e, which is in the materials that accompany this, that imposed it. And the reason it was imposed was because previously, when there were no contest settlements, some of the respondents began to make noises like, well, we only settled because we wanted to get it behind us, we really didn't do anything. And the SEC then came to view a failure to say that there was no denial as, in effect, a refusal to admit. And that's what the rule says. But when staff looked at the SEC and they put out a proposal in 2011 suggesting that we might, inviting comments on their proposed no contest settlement solution, they were kind of blindsided by Judge Rakoff in New York, who rejected the SEC's Citigroup settlement on the basis that, in effect, as I read it, and I'm reading it narrowly here, there was no admission. And so he concluded that there were no facts on which he could determine that the settlement was fair, reasonable, and that an injunction was warranted. That led to a more difficult debate for the OSC, and in fact that led to, I think, the commissioning of the paper that I wrote that you have in your materials. The OSC ultimately decided to accept no contest settlements in 2014 in appropriate cases, but those excluded cases where there was fraud, abuse, or criminal conduct. And they accepted in doing that the approval of a no contest settlement can be in the public interest without an admission of facts. And it can be based on allegations by staff that staff believes to be true and supports, and the benefits of settlement early on in the light of the terms of the settlement agreement. So the OSC altered its view on what the public interest required. And they did that, I might say, and I'm going to anticipate what Stephen would do to correct me. They did that, I might say, before the Second Circuit reversed Judge Rakoff. So what you have now is a staff policy on credit for cooperation that outlines the considerations that OSC staff will take into account when determining whether to agree to a no contest settlement. I've previously said that, well, let me say two things. The SEC's practice changed after Judge Rakoff. Prior to his decision, his rejection of Citigroup, the SEC had accepted no admit, no deny settlements, even where the respondent had been found guilty of criminal conduct or pleaded guilty in a criminal proceeding. They changed that. They no longer do that. And subsequent to Judge Rakoff, the SEC also decided and announced a policy through Chairman White that they would, I guess I should say, no, Chairman White is right today, that they would not accept a no contest settlement in cases of gross abuse or gross fraud. But and I've argued that as a result of these ongoing developments, both have moved toward a middle position. But in fact, the proof is in the pudding, and I think we have to wait to see, because many of the SEC's no admit, no deny settlements are settlements where fraud has been alleged. And one example of that I'd suggest, even if the actual settlement doesn't say fraud, and one example of that became difficult in British Columbia a few years ago in the Lines case, in which the SEC had accepted a no contest settlement for a pump and dump scheme, which presented a problem on the BC Commission's attempt to create to issue a reciprocal order. Nevertheless, let me just say a couple of things about the issues that underpin this. I have 1 minute to do it. On one side, you have the staff's desire for efficiency, the limited resources that all regulators have, and the need to harness them in the best way possible. On the other side, you have those who seek some kind of accountability that they associate with admissions, or you have people like Judge Rakoff who just thinks there's a public interest in having the truth come out. I have problems with Judge Rakoff's position because it wasn't clear to me that even in the days where admissions were required, that the admitted facts are comprehensively true. Settlement agreements are negotiated. The facts that get into them are the ones that staff will accept and a respondent will admit. And there are frequent cases where the trade-off was that there would be admissions of a public interest contravention, but no contravention of the Act, because that could go to civil liability. On that note, I've been told my time's up, so you'll all be happy to hear that for the first time in my life, I'm going to listen, and I'll stop here.
A round of applause.
I can supplement that.
So we're going to move on to Kelly, and she's going to give us a little more color about how the OSC staff perspective on no contest settlement works.
Thank you, Mary. Before I begin my remarks today, I just want to give our usual disclaimer that the views that I'm going to express today are my own and do not necessarily represent those of the Commission or my colleagues or Phil. So,
no one, anyone says ever represents my views.
Our enforcement program at the OSC is designed to meet three key goals, which is investor protection, accountability, and deterrence. The more quickly and effectively we can resolve enforcement matters, the better the outcome for investors and the capital markets. So what this means is by imposing a higher volume of protective orders earlier in the process, by achieving sanctions that are closer to the time of the misconduct, and by freeing up staff resources to pursue more actions and pursue more serious crime, that's for the benefit of investors. And one of the initiatives that we believe has improved enforcement's effectiveness, and albeit its early days, is our no contest settlement program that we adopted in March 2014 following extensive public consultation. But it's important to know what the history behind leading up to that proposal by staff was. And what we were seeing is that our cases were much more complex. They had novel issues, multiple markets, cross-border issues, and an increasing number of respondents. We looked at some of our statistics, and over 5 years, we could see that our settlement percentage had been ranging around 70 to 80% and had decreased in fiscal 2013 to 50%. So I can speak for staff and say we are not masochistic, and we thought we needed to do something about this to improve our effectiveness and our efficiency. And so what we looked at was implementing the no contest settlement program, and as well, we're all about to, Tom alluded to in the previous session, embark upon a whistleblower program. And we think that these are very important investor protection initiatives. But the one thing that I would say about our no contest settlement program is it's not a one-size-fits-all program. There are very high hurdles that respondents will have to meet in order to be eligible for staff to propose a no contest settlement program. And Phil did allude to what the factors are. So for example, no contest settlement would not be available in circumstances where there's been abusive, fraudulent, or criminal conduct, where investor harm remains unaddressed, or where the respondent has misled or obstructed staff in its investigation. Rather, the factors that we would be looking at to propose a no contest settlement will be the extent of cooperation and the timeliness of self-reporting by the respondent during staff's investigation, whether the remedial steps taken to address the misconduct, and that could include compensation as well, are sufficient. But that said, any settlement still involves the balancing of many factors to achieve the best outcome in the public interest. And as with our existing settlement process, there's a public hearing that will be held. Respondents will suffer reputational damage, and they will be expected to address investor harm. To date, the Commission has approved 2 no-contest settlements. The first one was on September 30th, 2014, and this related to the Ernst & Young audits of Sino and Zengui, where staff had alleged that Ernst & Young had failed to conduct their audits in accordance with generally accepted auditing standards. And as part of that settlement, Ernst & Young agreed to pay $8 million. The detailed facts and conclusions asserted by staff in the settlement agreement provided guidance to other market participants on audit deficiencies. In addition, Ernst & Young took significant remedial steps in improving its policies and procedures with respect to auditing reporting issuers in emerging markets. And the second no-contest settlement was approved on November 13th of 2014. And this related to 3 registrants that were subsidiaries of the Toronto Dominion Bank. The settlement arose following TD Bank self-reporting instances where clients had been overcharged fees. Staff alleged that the TD registrants breached their obligations with respect to effective compliance systems. And while TD neither admitted nor denied staff's allegations, as part of the settlement, they agreed to compensate investors upwards of $13.5 million and to pay a voluntary payment to the Commission of $650,000. In addition, TD Bank regularly is reporting to staff with respect to improved compliance policies and procedures to ensure that this problem does not occur again in the future. So in summary, while it's early days, I think that we've had some very good results with respect to our no-contest settlement agreements, and we believe that they've helped us advance the Commission's mandate and going forward with respect to maximizing the regulatory outcomes that we can achieve on behalf of investors.
Thanks very much, Kelly. And so for the U.S. perspective on no-contest settlements, we're delighted to have Stephen Cohen with us. Thank you, Stephen.
I'll stand by my disclaimer from the last panel. Well, you've already had the benefit of hearing about the U.S. system from a fellow Canadian, so I don't know that I have to go into too much detail. Phil, as always, did a nice job. We have debated and can debate the origins of different, pieces of our policy, but just for these purposes, and probably because I have a sneaking suspicion I'll be defending the policy in a few minutes, I'll just give you a little bit of perspective about it. Just a couple of things as we have this discussion and the debate. I do think it's important and useful to look at the U.S. program from the context of its origins. Phil described some of it, but what I mean is, whether you call it culturally or just as a matter of perspective on how you value it, just understand regardless that for decades we've been doing it this way. For the moment, I say that not as a bizarre sort of defense, but rather understand that we just have been doing it that way for a variety of reasons. I'll give you one in a second, and so we take for granted in the first instance in this space that these types of settlements are a useful way for us to achieve some of our accountability goals in the context of our broader accountability program, which I'll speak in a second. Understand also that in the U.S., and I don't pretend for a moment to be an expert on Canadian law, I've looked at some aspects of it and had lots of experience working with my colleagues in various provinces. The criminal law in the U.S. is precisely coextensive with the civil law, which is to say, one who admits a violation of our law, our fraud law, is admitting to a crime for which they can be put in jail. So I'm not suggesting one way or the other whether that means that you should or shouldn't have that as a measure of accountability. Just as you think about reasons why one might have that system and the costs to somebody in our system And I'm not suggesting that precisely as there isn't the case for you all. I think that there's some variations on different laws in different places, but our criminal law, there isn't a different criminal law. It's precisely the same law. So that creates challenges for us, and I think for our expectation that in every instance, people would admit to wrongdoing. As we talk about the reasons for no contest settlements, if you will, we don't use that term, but I'm just going to use that term because I think it fairly captures it and it's consistent with how you all describe it. We do, as Phil described, have a policy that we refer to as neither admit nor deny, which I guess I would note as you think through the potential accountability. I mean, it is the case that people cannot deny the wrongdoing. And I will leave for people to decide, and I will assert, as we talk about this further, that there is sufficient accountability, the lion's share of our cases under our system. So I guess the last thought I will give on this is, well, the last two thoughts is one, as Phil mentioned, so as I mentioned, we come from different perspectives. The system here has been for a very long time, everyone has been required to admit, and there is a discussion ongoing now about potentially having no contest settlements. And so just remember, we've been for decades allowing situations, settlements where people have not admitted to wrongdoing, and we are moving toward the more accountability of admissions. So I think there's common understanding, is a long way of saying, that there is accountability achieved by admissions of wrongdoing. And I think, as Chair White instituted the policy and as we have been bringing cases in that regard. So I'm just trying to narrow the goalposts a little bit, and I think the discussion is around whether and how much accountability in different kinds of cases can exist in a world where you have people not admitting to wrongdoing. Where we are moving is, in certain cases where we believe the additional measure of a public admission of specific facts is necessary, we are requiring admissions of wrongdoing, including those cases where there may be broader civil or criminal liability. But we do believe, and I'll save for later why, that our enforcement program is about, there are several aspects to how we achieve accountability. And so our philosophy around why we accept these settlements is that when you look at the package of our settlements, and candidly, the volume of cases we believe we're able to bring in that context, we do believe we are achieving the appropriate level of accountability in most of these instances, and we'll get into why perhaps in the coming minutes.
All right, thanks very much, Stephen. And so finally, for the academic perspective on this debate, we'll turn to Anita Anand.
Mary, I don't know if it's the academic perspective, it may be the investor protection perspective. We'll just wait and see. My starting point in any case is to remember that the historic purpose of securities regulation is investor protection, and it's an explicit purpose in section 1.1 of our statute. And my position today is that no contest settlements add to what I call the investor burden. And I'm making 3 points. First, the scheme does not have general deterrent effects. Second, investors will have an impeded ability to recover under the scheme. And 3, their private actions will also be negatively affected. So we know from key Supreme Court of Canada decisions in asbestos and Cardaway that it is acceptable for securities regulators to take both specific and general deterrence into account while sanctioning. In terms of specific deterrence, there may be a deterrent effect when a settlement is reached between the Commission and the violator of securities law. But I would question the likelihood of specific deterrence given that there is no necessary admission of violating the public interest or contravening Ontario securities law. I found it very useful to hear Kelly's summary of the 2 no contest settlements where it does appear that there has been specific deterrence with regards to the defendants. But my point relates more to general deterrence than specific deterrence, given that that is also a goal of the regulation after asbestos and Cardaway. I think there's likely little general deterrence that will occur as a result of a no contest settlement. One of the main reasons for no general deterrence is that no written reasons necessarily accompany the settlement. So it's important for investors and capital markets participants, broadly speaking, to develop a body of law and at the very least to have written reasons for settlements. Written reasons would contribute to general deterrence being achieved. Now, having said that, I will say that in the two examples we do have written reasons, and this is a great precedent, but they're not required under law, and so there is the discretion under our current rules not to provide written reasons, but I would encourage movement towards that, establishing that as a precedent. But as Stephen alluded to, no required written reasons also may raise an accountability issue. He was referring to accountability generally speaking, but I'm focusing on the movement that I think we need to encourage towards greater accountability when you're dealing with a regulator that has an extremely broad mandate and a very broad public interest power. I think we need to be ensuring this movement that Stephen alluded to towards accountability. Now, the public interest, moving on to my second point relating to investor recovery, the public interest power under the Securities Act does not ensure recovery for investors either by way of compensation or restitution. Discretionary compensation may be made, as we saw under the ADCP distribution. Now, the OSC in the no contest context must approve the respondent's proposal for no contest settlement in a public hearing based on a determination that resolving the enforcement matter via no contest is in the public interest. So two implications. First, there's, again, no necessary payment out to investors, no written reasons necessary to support the Commission's discretionary power to pay out to investors or not. Second, if there is an ability to hold a hearing of this sort, doesn't this detract from the efficiency gains of no contest in the first place, which is supposed to be one of the primary motivations for this system? And then finally, I'd like to just say a word about civil versus regulatory proceedings. Not requiring respondents to admit to violating securities law or the public interest during the settlement process may increase the difficulty associated with civil proceedings and class action specifically, potentially undermining the deterrent value of civil litigation. No contest settlements are defendant friendly, since the same defendants in a civil action can deny the alleged facts upon which the settlement was reached. A no contest settlement where no admissions are made works in the defendant's favor in the subsequent civil proceeding. Now, you might ask, well, why should the securities regulator be at all concerned with the extra regulatory or the civil matter? On a narrow reading of the investor protection securities regulatory mandate, this may be a legitimate point. But what I'd like to do, and maybe this is the academic in me, is to stand back and look at the regulatory regime as a whole. Implementing a program which makes it more difficult for investors to recover and take actions to recover for harms done seems to conflict with the objective of investor protection. I see this in the big picture. In recent years, the Commission has made incredibly significant moves towards further protecting investors with the establishment of the Investor Advisory Panel, the Office of the Investor, and with the whistleblowing program that we heard about. But in terms of no contest, I think we're not taking a step forward as we are in those other initiatives. I see difficulties with the issues relating to no mandatory written reasons, no admission of wrongdoing, no admission of violation of the public interest, and all of that, in my mind, is contrary to investors' interests.
Well, no. Thank you, Anita, for raising a number of interesting issues. I will give Phil a chance to respond in a moment, but the first question that I want to pose is actually addressed to Kelly, just because I think it furthers this theme that Anita raises about accountability and so on. So it's sort of a two-part question. The first is, has has staff noticed any difference in how they negotiate these no contest settlements as opposed to how they would have negotiated a traditional settlement, which would have included admissions within it? I realize 2 occasions is not a huge sample, but perhaps you can begin to speculate on how that negotiation process works and what the differences might be. And the related question, again along this line of accountability, is you very helpfully provided a number of factors that are elucidated in the credit for cooperation policy that sort of describe some of the exclusions where staff won't consider a no contest settlement. But how do you respond to the suggestion that they still leave you with a huge amount of discretion that really doesn't constrain your ability to make that decision that you're going to ultimately allow a respondent also?
That's a very long question, so I might break that down and talk about a few things. One being the accountability issue. I see there's accountability for the wrongdoer, which is equated to admissions, but I think there's more broad question of accountability also relates to staff and how we allocate our resources to maximize our investor protection efforts. Now, with respect to how we would negotiate settlements varying under no contest settlement versus historical. Again, this is early days that no contest settlements under our revised policy are available. But really the factors that we would consider fundamentally are the degree of self-reporting, the cooperation that the respondent is making, with respect to the investigation, with the view to trying to resolve this matter effectively and efficiently, while also recognizing misconduct has to be remediated, investor harm needs to be addressed. So I would say that, since we have both settlements available, it's just going to be a function of, are they meeting the factors that staff would consider appropriate in recommending a proposed no contest settlement. On the issue of accountability of the wrongdoer, I would see it not necessarily equating just with making admissions. I think we take accountability of wrongdoers very seriously, and we want them to take responsibility for their actions. So this includes timely reporting, cooperating with staff, financial compensation to investors, payments to the commission, costs to the commission being paid, remediation of any type of misconduct, whether that's improvements, internal controls, etc., all with the view that that being part of the settlement, I would say they are taking responsibility for their actions, and that settlement agreement is going to be in the public domain, and those respondents will likely suffer reputational harm from that. On the issue of deterrence, again, it's a balancing factor, accountability of the wrongdoer and deterrence. And as part of staff's work leading up to the policy hearing and proposing a no contest settlement program, we felt it would increase the deterrent function of enforcement. We spent a fair amount of time dealing with criminologists that work in the area of white collar crime. And what we found that deterrence is equated to 3 factors: the timeliness of the sanction, which no contest settlement speeds up the timeliness of the sanction relative to the time of the misconduct, the severity of the sanction, but most importantly, the #1 driver of deterrence was the certainty of the sanction. And certainty of sanction is the fear of apprehension, or the fear that possible wrongdoers would have that they're going to be caught, and the ability for the commission to actually resolve matters more quickly and effectively and focus on pursuing even more matters and more serious financial crime will increase our deterrent function in the marketplace.
That's specific.
Okay, so in fairness to Phil, I cut him off before, I'll let him go in now, and then you can go after him.
No, I just want to add to that. I think Kelly said much of what I would have said. I happen to think of accountability in terms of deterrence, and because those who have a kind of visceral desire to see someone admit because somehow it satisfies them psychologically don't excite me. I just don't think that's part of the commission's function, but I think deterrence is. And what Kelly talked about was specific deterrence. You're giving me 15 minutes You couldn't be.
No.
Deterrence. I know. Deterrence. Specific deterrence flows out of the sanctions and all of the other things that Kelly talked about. But the other element that's there is general deterrence. And the factors Kelly mentioned go to general deterrence. And interestingly, in both of the approval decisions, in the E&Y case and in the TD case, Mary and her colleague Jim Turner both focused on general deterrence. And if any of you has read Gretchen Morgensen's column yesterday in the New York Times, what she described was a study that showed that a pattern of misstatements in financial statements diminished significantly after one of the perpetrators was prosecuted. And that includes no contest settlements. So there's an empirical basis, I think, for general deterrence. Now, I think I'm going to go on for about 1 minute. I think there is one other kind of accountability that we're not talking about. Kelly talked about staff accountability, and that's valid because adding an arrow to their quiver, I think, gives staff more power in terms of making settlements and dealing with respondents, and that can easily play into greater compensation when settling. But the kind of accountability that I think is also important is the Commission's accountability. And that goes to what the Commission does in approving settlements. Our practice when we had, in the old days, was that for a settlement to be approved, you'd go into a public hearing, the Commission would close it during the submissions, and if it approved the settlement, all of the transcripts of that hearing would be made public. That resulted in a couple of embarrassing cases like Copeland, which some of you may remember, the Americans won't, but basically the Commission rejected a settlement that staff had signed on to, and that became public because they didn't approve it, and they had to go back and get the settlement. What that led to our current practice, which is a pre-settlement conference with a commissioner who informs the parties whether that commissioner thinks that this settlement can be approved, and if the commissioner says yes, then it goes into a public hearing and we get this semblance of a new public hearing, and you get the reasons if they're issued, and they're usually some issued. Well, it seems to me that we'd have greater Commission accountability if the old practice were imposed on the current practice, and if the pre-settlement conferences were transcribed and became public upon approval of a settlement. And I actually think that would help everybody to understand the process better. I'm going to stop there. There are downsides that some people might argue about it, but put simply, it's not a mediation process, so there's no privilege. It's not it's closer to an arbitration, but it's not that either. It's a quasi-adjudicative hearing where the commissioner determines whether this settlement can go public. And I think that process itself should be public to ensure greater accountability on the part of the Commission itself.
Thank you, Anita.
Kelly mentioned 3 factors that are important for deterrence: timeliness of the sanction, severity of the sanction, certainty of the sanction. I do not see how those 3 factors go to general deterrence when you have no obligation to provide written reasons. General deterrence speaks to the world at large. It doesn't speak to that particular wrongdoer. And so I guess I'm asking for a little bit of clarification from Phil or maybe Kelly on how general deterrence is served by these no contest settlements.
Well, maybe we could bring Stephen into the conversation from the U.S. perspective. So going back to this issue of whether or not that objective is served by the type of settlements that have been common in the U.S., what's your perspective?
Sure. Do you want me to limit this response to the general deterrence, or you want to give the broader?
You can
Yeah.
proceed however you like.
Okay. first of all, I think it's important to balance general and specific deterrence. In the first instance, maybe this is my own view of my role as a regulator, but I guess we were talking about investor protection. I mean, that is our mission, that's our purpose. And so when I'm looking at a case and a wrongdoer, while our program is contextualized around general deterrence and it's important to us in all of our settlements, first and foremost, my job is specific deterrence. If I have a wrongdoer, I need to make sure that wrongdoer is not in a position to harm somebody else. That's my first job. General deterrence is important, and I think you achieve that not always in the context of a single case, but rather in the context of a program. And so we view part of our general deterrence as arising out of the entirety of our program and how we are achieving and how we are stopping and how we are holding people accountable across the range of things we do. So I guess maybe I take a slightly different perspective and not divorce, but maybe contextualize the difference between specific and general deterrence. To that end, I don't think they're mutually exclusive. And so I think as Phil was alluding, I actually don't agree that settlements that, in all instances, that don't require admissions don't provide general deterrence. In our situation, we issue a detailed set of facts, whether it's an administrative hearing or a federal court proceeding, which lays out the findings of the commission as a result of our investigation. And this is just my personal opinion. I understand that people prefer admissions, and we have done that in certain cases, but I guess I don't think that the public is fooled that when we lay all these facts out, maybe it happened, maybe it didn't. I think most people look at it and they say, gee, there was a government investigation, they found these 10 or 15 or 20 pages of facts, and I think people presume that the defendant did it. And I think they conduct themselves accordingly. So I think there's a great amount of accountability and transparency when you publicly say what someone did wrong and they're willing to settle to it. And so I think admissions have an important role, but to say they're required in every case, I don't agree. And so to the specific deterrence, why do we think it's successful? I mean, this is just one aspect of it, right? And so I really applaud. I mean, Kelly went through some of the factors that are very similar to how we look at it, but I mean, appropriate sanctions are important. We need to bar wrongdoers from the industry. Before we worry about all this other stuff, if they're a broker or an investment advisor or a public company officer or director, we got to get them out. And sometimes we have investigations that go on for years, and sometimes we litigate with investment advisors who still have customers for years, and we think that they're committing fraud, and we don't stop them until we bring our proceedings. So if we can get them barred tomorrow and get their clients out of their employ, so they're no longer managing people's money tomorrow, as a result, instead of 3 years from now, maybe a judge will find they committed fraud, and then they'll stop having customers. I pick the former over the latter, and that's I think that's a really important way to look at it. Getting money back to investors quickly is an important part of our program. And when we litigate, it takes years for us to get money back to people. It's not an end in and of itself. It's not the only reason, but it's a factor. And I guess similarly, I think for the entity side, not the individual side, in our corporate settlements where we do neither admit or deny settlements, we oftentimes put into place what we view as pretty important corporate reforms that have immediate impacts to investors and others in those contexts. We put consultants and monitors and others in place who are in a position to affect corporate behavior, changes that we don't think would happen for a very long time. So the last thing I'll just say is the resources, which you talked about. I'm trying to think of a different word other than academic to talk, because I don't mean it, I really legitimately don't mean it to sound pejorative about the debate around efficiency versus accountability, but speaking for myself, and I've had lots of conversations with Tom about these kinds of things, I make the very real choice every day. Can we open an investigation into this fraud? And I have so many resources, and quite candidly, I settle a lot of cases every year, dozens and dozens and dozens of them. And I also can look at, say, the Gorman case, which is very public. We sued somebody, Mr. Tour, we won. And people said, great for the enforcement program. You finally sued someone in public court, you went to trial, and you won. Do you know how much that cost for us to do that? And I don't know the numbers, but if you think about that in comparison to how many other cases we might have brought, I think it's just an important part of the debate for people to think about. I'm not saying we should be in court, we should be going to the mat, we should be requiring admissions in certain cases, but we should also be settling without admissions if we think it meets all of the goals of our program.
And let me add to that, just because I don't think Stephen explicitly addressed Anita's criticism about reasons, but what Stephen said about the summary of facts that the SEC publishes is equivalent to reasons. The OSC publishes settlement agreements which describe the conduct, and staff confirms that they believe that that conduct is provable. Those are as good as reasons, because the people you want to deter are people engaging in similar practices, and they can read it and see what you're doing.
There's a question from the audience. Thank you, Phil. There's a question from the audience, from Cynthia Williams, actually, about deferred prosecution agreements. And the question is, and this is a question directed to whoever would like to answer, do the panelists think that deferred prosecution agreements raise the same concerns as no contest settlements? And I guess this is the part that's specific to the OSC. Is there any move for the OSC to consider deferred prosecution arrangements?
The broader question of deferred prosecution agreements, I'll leave to Stephen, but as far as a move for us currently, it's not something that currently we're looking at, and currently our resources are focused on no contest settlement first, whistleblower going next, but we're always open to looking at any types of additional tools that we can put in our toolkit to increase our effectiveness and meet our key goals of accountability and deterrence.
Just really quickly, for us, our deferred prosecution agreement program, which is similar to but slightly different than a long-standing program by our Justice Department, is really part of our overarching cooperation program. So we view it in a context of where often an entity, sometimes an individual, will be a cooperator, and we view them as having come forward, having come clean, having been helpful, having cooperated, potentially being remorseful, for example, although I'm not suggesting that's a requirement, but having come forward and participated in rectifying or remedying the misconduct or our investigation or the litigation, we view them as less of a threat in theory, right? And so the deferred prosecution simply says, we'll wait till later to prosecute because we really value your cooperation. So I think, is that a deterrent in and of itself? Well, it's a deterrent in effect because of what it allows us to accomplish. I think more importantly is it's similar to the whistleblower debate. What are you gaining by having that as part of your arsenal? And I think it's a great closing point on that, which is to say the flexibility to have all of these tools for people who are hopefully responsibly looking at how to achieve deterrence generally are really important. It's a flexible tool in our arsenal. We appreciate using it.
Okay, I think, although we're a minute early, I think.
Can we just talk about one more thing?
Yes, please, Anita, you may talk about one more thing.
Well, I just wanted to get the panelists' reaction to my point about the civil versus regulatory proceedings, because I think that, even if we were all at item on the regulatory front, there's still a point to be made that investors have a harder time in the civil proceeding under this scheme. And I'd be interested to hear if anybody agrees with me. I don't know if they disagree.
Phil, any comments?
No.
Okay. There was one other issue that you guys wanted to discuss briefly, so I'll give you the final word on reciprocal orders.
Reciprocal orders raise an issue with no contest settlements, only because Ontario is the only commission in the country that does it openly. Other commissions engage in settlements through undertakings, or have in the past, BC, for example, Alberta at one time. But the more important question, it seems to me, is whether in our legislation we have a provision that permits what we call reciprocal orders, which permits, take Ontario, the Ontario Commission, to issue an order within its power after a hearing on the basis of an agreement involving sanctions that a party has entered into with another regulatory authority in Canada or elsewhere. And there's been some question about how they work. There's a decision in BC called Lines, in which the BC Commission imposed a sanction on two men named Lines who had entered a no admit, no deny settlement with the SEC relating to a pump and dump scheme. And what the BC Commission did was prohibited them from trading in BC. Unfortunately, the consent judgment in the injunction in the US only prohibited them from trading in penny stocks on the basis of the provision under which they were charged, in effect. in the US. Well, they got counsel, they took it to the BC Court of Appeal, and the BC Court of Appeal said that on a reciprocal order, you can't increase the sanction, and they rejected it. That made no sense to me, but it has a number of implications, one of which is that the SEC might consider reciprocity when it deals with pump and dump schemes and settlements. I'll leave that to Stephen. But the other is how we deal with reciprocal orders in Canada. Alberta has recently adopted a provision in its act that says any sanctioning order made in any province in Canada automatically applies in British Columbia unless it's a no contest settlement, in which case the Alberta Commission has to hold a hearing before they can reciprocate. And presumably, or either has to make the decision with or without a hearing. Presumably the hearing provision was a response to the Lines case. But I think issues are going to develop here. I frankly do not see why a no contest settlement shouldn't have been treated in the same way as any other sanction from the OSC, for example, under the Alberta legislation. I'll stop there.
All right, well, on all of your behalf, I want to thank the panelists very much for their interesting discussion, and they've given you lots to think about, so I hope that you can do that.